After 36 days of trial proceedings, stretched across witness testimonies, cross-examinations, a trial within a trial, and closing arguments, Judge Nathan Erasmus delivered his ruling in the high-profile case of the state versus Appollis, Van Rhyn, and Smith, finding all three accused guilty of human trafficking and kidnapping of 6-year-old Joshlin Smith. Before we dive in, I just wanted to send a personal thank you to new members of our channel. Thank you for subscribing. For us, a self-funded media publication, this means a lot. Judge Erasmus began with the law. He turned to PACO-TIP Act 7 of 2013, the cornerstone legislation on trafficking in persons, citing specific provisions, sections 4.1, 10.1b, and 10.1c, which lay out the criteria the state must meet to prove a charge of trafficking. What was done, how it was done, and why it was done. In the case of a child, he reminded, Section 11.1 of the Act relieves the state of proving quote-unquote means, such as coercion or deception, provided it can prove the act and the purpose. The court accepted the state's use of S versus Ngazana as persuasive authority, a precedent-setting Eastern Cape case, in arguing that when a child is involved, consent or the means used becomes immaterial. Erasmus said plainly, he agreed. What followed was not a clinical delivery of facts, but a deliberate, unflinching excavation of the evidence. Erasmus laid out a comprehensive narrative, drawing threads from across the trial, plea statements, witness testimonies, and the video-recorded alleged confessions. He detailed how between the 18th and 19th of February 2024, Joshlin Smith, then 6 years old, was trafficked, not abducted by a stranger, but handed over, sold for 20,000 rand, as confirmed in various forms by multiple parties: Kelly Smith, her boyfriend Jacquen Appollis, and their close associate Steveno van Rhyn. Judge Erasmus returned repeatedly to the quote-unquote mosaic, a term he used to describe how disparate pieces of evidence viewed independently might appear trivial, but together created a full picture of criminal conspiracy. He cited Advocate Swanepoel's analogy, each piece a tile in the larger image. At the center of that image, Kelly Smith, the child's mother, whose conduct throughout the trial became its own form of testimony. Erasmus explained Kelly's behavior in detail before, during, and after the disappearance. She failed to alert authorities until prompted by a neighbor. She slept soundly while others searched for her child. Told multiple people, open quote, Joshlin made me famous, close quote. Danced at a prayer event days later. Referred to her daughter not by name, but as quote unquote, the child. Lied about why Joshlin didn't attend school on the 19th of February. Remained cold, evasive, and unbothered during questioning, and most damningly, never once participated in the search. The judge underscored this: Kelly's actions made no sense if she were innocent. Two key figures shaped the state's narrative. Nico Kutsia, a casual acquaintance of Kelly, testified to a chilling exchange in August 2023, long before Joshlin vanished, in which Kelly said she would, open quote, let the child go far, close quote, and that people would search and find nothing. Open quote, it will look like a movie scene, close quote, she told him. She asked him to imagine what would happen in Middelburg and Deesville come January or February. The judge found Kutsia credible, noting that he had no motive to fabricate the story, and even accurately cited the 20,000 rand sale price before it was public knowledge. Lourentia Lombaard, the state's Section 204 witness, provided a fragmented but corroborated account of the events surrounding Joshlin's disappearance. While the judge acknowledged her multiple versions of events and her own involvement, he ruled that enough independent evidence, including parts of Jacquen and Steveno's confessions, Kutsia's testimony, and witness observations, substantiated key elements of a story. The judge laid out how the actions of the accused satisfied the legal elements of both human trafficking and kidnapping. Joshlin's freedom of movement was taken from her. She was treated as a commodity. There were promises or payments of money, and by legal definition, she was reduced to a person under the control of others, a condition that satisfies the PACO-TIP definition of modern slavery. For kidnapping, the elements of deprivation of liberty and unlawful removal were also met. So on count 1, human trafficking, guilty. On count 2, kidnapping, guilty. All 3 accused, Kelly Smith, Jacquen Appollis, and Steveno van Rhyn, were found guilty on both counts. The courtroom gallery erupted into applause. While the ruling brought the trial to a close, one major question remained unresolved: the immunity of Lourentia Lombaard. Judge Erasmus deferred ruling on whether she will be granted full immunity under Section 204, stating he anticipates further evidence may arise in the next phase of the case that could impact that decision. As the Joshlin Smith trial approached its culmination in Week 9, courtroom tensions sharpened, giving way for the final legal battle, the closing arguments. The state was now fully set. All testimony had been given, the facts laid bare, and now it was time for both sides to put forward their final pleas. What followed in the courtroom across 2 intense days of closing arguments was a critical dissertation of the evidence presented, the law as it applies, and the reliability of witnesses who stood at the core of this harrowing case. Advocate Zelda Swanepoel opened the state's closing submissions by acknowledging an unavoidable truth. This case was unlike any other trafficking matter previously adjudicated in South Africa. Typically, such cases rely on the testimony of the victim. Here, there is no victim. Joshlin Smith remains missing, but this, she argued, should not be the state's burden alone. Instead, what the prosecution set out to prove was that Joshlin was indeed trafficked and kidnapped, and that the 3 accused, her mother Kelly Smith, her mother's boyfriend Jacquen Appollis, and their friend Steveno van Rhyn, were part of a plan that commodified and sold a 6-year-old child. The state leaned heavily on the Prevention and Combating of Trafficking in Persons, or the PACO-TIP Act. In particular, Swanepoel drew the court's attention to Section 4.1 defining trafficking and Section 11, which specifically addresses cases involving child victims. She emphasized that when a child is involved, the legal threshold for proving trafficking is lower. Unlike adult trafficking cases, there's no need to prove quote-unquote means, the coercion or deception used to carry out the trafficking when the victim is a child. From this legal standpoint, the state argued the plan to sell Joshlin was open quote trafficking in its purest form, close quote. She highlighted 3 elements. 1. What was done? Joshlin was handed over to unknown individuals. 2. How it was done, through coordination and planning involving all 3 accused. 3. Why it was done, for the purpose of exploitation, potentially for body parts, as inferred from witness accounts. Swanepoel made no attempt to overstate the credibility of Section 204 witness Lourentia Lombaard. She conceded that Lourentia was not a quote-unquote perfect witness. The court heard about her history of drug abuse and the inconsistencies in her earlier statements, but the state urged the judge to assess her testimony holistically rather than in isolation. Open quote. If it had only been Miss Lombaard's evidence, close quote, Swanepoel admitted, open quote, that would be a problem. But it isn't, close quote. The state's approach was to bind together corroborative pieces, testimonies from investigators, contradictions in the accused's own statements, and moments that, when considered together, revealed what Swanepoel called the quote-unquote golden thread, a consistent, overarching narrative pointing towards guilt. Swanepoel also defended the testimony of Nika Coetzee, a key witness who testified that Kelly Smith had previously spoken about wanting to, open quote, get rid of her children, close quote. She called him, quote unquote, an excellent witness, noting that his version was supported by reports and that, open quote, there is no way he made this up, close quote. The prosecution rejected the notion that Kelly was the victim of an opportunistic betrayal. Open quote, the only one who wanted fame was Kelly Smith. She told people, Joshlin made me famous, close quote, Swanepoel argued. Ultimately, Swanepoel insisted that all 3 accused knew what they were doing, stood to benefit financially from the sale of Joshlin, and collectively participated in a premeditated act of trafficking. On the defense bench, each counsel approached their final arguments with an eye to dismantling the state's case by targeting its weakest links, the witnesses. Advocate Nobathle Mkabayi, appearing for Steveno van Rhyn, led her arguments with a frontal assault on the credibility of Lourentia Lombaard. She argued that the 204 witness lied, quote-unquote, uncontrollably, even under the comfort and reassurance of Constable Refilo Sekgobe. Open quote, by October 2024, several months into custody, she gave a 204 statement littered with lies that were exposed under cross-examination, close quote, Mkabayi said. She questioned how the court could accept a statement made so long after the fact, especially by someone who, by her own admission, was a habitual drug user. Open quote, Was she still relapsing in October 2024? Close quote, Mkabayi asked rhetorically. Mkabayi argued that the state built its entire trafficking and kidnapping case on speculation and faulty witness testimony. Open quote, when you traffic, you don't traffic alone, close quote, she said. Open quote, who was the other person, close quote. She posited that the accused's only quote-unquote common purpose that day was to sell a microwave, not a child. According to her, there was no quote-unquote compelling evidence showing her client trafficked or kidnapped Joshlin. Instead, she accused the state of failing to provide any information about the people who allegedly received Joshlin. No names, no addresses, and no real proof of exploitation. As for the torture claims initially raised in the trial within the trial, Mkabayi conceded the court had already dismissed them but reiterated that her client was kidnapped by police, assaulted, and coerced into a statement. However, she did not push this line heavily, knowing that these statements had already been ruled admissible. Advocate Lourentia van Rhyn, representing Kelly Smith, took a more methodical approach. He narrowed in on Lourentia Lombaard and sought to paint her as the architect of a false narrative forged under pressure. He reminded the court that she was a habitual methamphetamine user for 16 years, using up to 3 times a day. Open quote. Even when explaining discrepancies in her confession, she claimed her mental faculties were impaired, close quote, he said. He called her an opportunist, someone who manipulated the system to save herself and threw Kelly under the bus when it suited her. Van Rhyn raised concerns about Lombaard's alleged eavesdropping through a broken window, calling it fabricated. Open quote. She couldn't have heard it. She must have been present. That story was made up, close quote. He argued that there was no corroboration from either Jacquen or Steveno to support her version and insisted that, in the absence of such support, open quote, her evidence is so poor, it cannot be relied upon, close quote. Finally, Advocate Fani Harmser for Jacquen Appollis delivered what can only be described as a scattered, disjointed argument. He too fixated on the contradictions in Lombaard's testimony, particularly her differing accounts on whether the payout discussion occurred on Sunday or Monday. Harmser tried to argue that if the state truly believed in the validity of Jacquen's confession, then why did they seek a 204 statement from Lourentia that contradicted parts of his account? He claimed that the two versions, Jacquen's and Laurentia's, were quote-unquote mutually exclusive and that they quote-unquote can't both be true. At several points, Harmser stumbled, citing outdated legal precedents and getting into a prolonged back and forth with Judge Erasmus over case law. In one moment, the judge visibly showed his frustration, correcting Harmser on the record about Jacquen's contradictory statements regarding whether Joshlin and her siblings stayed home due to illness or dirty uniforms. It was a poor showing that did little to sway the court. In the end, the closing arguments captured the essence of a complex trial, a state building a circumstantial case without a victim, defending a problematic but informative witness, and stitching together facts with legal precision, and a defense attempting to raise doubt through attacks on credibility, inconsistent stories, and last-minute legal tactics. What followed next would determine the fate of the 3 accused and perhaps reveal at last the court's belief in what truly happened to Joshlin Smith. The courtroom may have delivered a verdict, but the Joshlin Smith story is far from over. As Judge Nathan Erasmus reminded those present at the end of his ruling, the sentencing phase lies ahead, and with it the final legal reckoning for Kelly Smith, Jacquen Appollis, and Steveno van Rhyn, all now convicted of human trafficking and kidnapping. But what exactly happens next? The court will reconvene at the Western Cape High Court on Friday, the 9th of May 2025, not for sentencing, but for what Judge Erasmus described as a quote-unquote housekeeping event. Here's what to expect from that appearance. The state will present aggravating factors, details, and arguments explaining why the court should impose the harshest available sentence. Prosecutors are also expected to introduce victim impact statements, possibly from relatives, caregivers, or members of the community who have been affected by Joshlin's disappearance. The defense teams, now facing a final opportunity to plead for leniency, will declare their intentions. They may request pre-sentencing reports or psychological evaluations to argue for reduced sentencing. Most significantly, the court will lay the groundwork for a sentencing hearing, which could follow in the weeks after once all reports and witness accounts have been submitted. Despite testifying as the state's 204 witness and offering deeply incriminating testimony about her role and the actions of the accused, Lourentia Lombaard has not yet been granted full immunity from prosecution. Judge Erasmus made it clear he is reserving judgment on that issue. He said plainly that while her testimony was pivotal, the court will still assess whether she complied fully and truthfully with the terms of her agreement and may still consider prosecution if it emerges that she withheld information or lied under oath. Under South African law, human trafficking, especially where a minor child is involved, carries some of the most severe sentences available. The Pakotip Act makes provision for life imprisonment or a minimum of 15 years for human trafficking involving children depending on circumstances. The court may also impose a concurrent sentence for kidnapping which can run as long as 25 years. Given the nature of this case, the premeditated planning, the lack of remorse, and the enduring absence of the victim, it is likely that the prosecution will argue for maximum sentences to be imposed. Outside the courtroom, the verdict has rekindled a renewed urgency to find Joshlin Smith. In a statement issued shortly after the ruling, Sports Minister Gayton McKenzie, who played a leading role in the early search efforts before his appointment to cabinet, shared a deeply personal and emotionally charged message. Open quote, "Dear Kelly, when I met you, it took me 5 minutes to tell my protectors that you are not forthcoming with the truth. We played you all along when we wined and dined you. Prison is a place of deep reflection. Please reflect and come clean regarding the whereabouts of Joshlin. We will find Joshlin, trust us, we will find her, and she will look you in the eyes, and at that moment your crime will be crystallized in your being. The search is starting now, South Africa. My trana rol vir daai kind." Close quote. McKenzie also announced that a foundation has been registered to secure the education of Joshlin's siblings and reaffirmed that the search efforts will continue with renewed resolve despite the verdict. Week after week, South Africans have followed every step of this courtroom odyssey. Each tearful testimony, each bombshell confession, each cross-examination. Now, after 36 days of trial and more than a year since Joshlin vanished, we arrive at the moment of reckoning. The court has spoken, but the search for Joshlin, the real search, the one that matters the most, is only beginning. To every person who followed this case, in pain, in prayer, in protest, thank you. To the subscribers, the supporters, the viewers who made sense of the story alongside us, your attention has kept this case alive in the public eye. And to Joshlin Smith, wherever you are, this story isn't over until you are found. We will be here every step of the way. This brings us to the end of our breakdown. If you made it this far in the video, thank you for watching. While we've reached the end of the Joshlin Smith trial weekly breakdowns, we have more content planned, more cases to unpack, and true crime stories to dive into. So believe me when I tell you, subscribing to our channel and turning on those post notifications is absolutely necessary. Also, visit our news website, swisherpost.co.za, for the best explainers on every important event happening around you. No agenda, just the story.